Yes, Mr. Omanga.
Your Honor, as I indicated earlier,
Yes.
we have an application to make pursuant to Section 214 of the Criminal Procedure Code, and the application is for leave of the court for the prosecution to amend the charge sheet to include the proper particulars, and we have presented to the court a draft of
Yes, Mr. Omanga, I can't hear you quite clearly. The application to amend
Your
the
Honor,
charge
the
sheet
court,
to include the proper particulars.
yes, proper particulars which were left out, and to be specific, first with respect to the dates in count one,
Of the date.
in count one, the dates are indicated as diverse dates from 12th May 2023 to 18th May 2023. We
You
wish
said diverse dates?
diverse dates from 12th May. That's the original charge sheet. 12th May 2023 to 18th May 2023. We wish to amend the same to read from the 11th date of May 2023 to the 18th May 2023.
Yes.
That applies also to count number 3 and 4. With respect to counts number 8, 9, and 10, we wish to amend the particulars to include the name of the ninth accused person in the original charge sheet. Lastly, Your Honor,
Ninth accused, that is Peter Njenga.
yes. Lastly, Your Honor, in the original charge sheet, the name of the ninth accused was written as John Maina Njenga, and we wish to amend the same.
Yes, please.
I can repeat, Your Honor, the
As
original.
John Njenga.
It's indicated John Maina Njenga, and we wish to amend the same to read John Maina Njenga Kamunya in all of the counts.
You saying John?
John Maina Njenga Kamunya.
John Maina Njenga.
Kamunya. As indicated in the draft charge sheet of furnished a copy with the court. So, Your Honor, in the interest of justice and for disposal of this matter in a timely manner, I pray that the application be allowed and the charges be read afresh to the accused persons in accordance with Section 214 of the Criminal Procedure Code.
Mr. MUNGIKI?
Yes, Your Honor, we are opposed to that amendment. Your Honor, if you look at the letter, spirit, and the philosophy that underpins Section 214, it is very clear that it is the court. It is the court. If the court realizes that a charge is defective upon hearing evidence, then the court, for substantive justice, can recommend a judgment, an amendment or a substitution of the charge, not because of anything, but because it wants to realize the interest of justice. But here, Your Honor, it is the prosecution that is proposing to amend. The question that calls for answers is, what was the hurry? Why were they in a hurry to rush to court and they had all the time until they even forgot the name of John? They are saying they are giving the name from John Maina Njenga to John Maina Njenga Kamunya. So what was this in so much hurry until they forgot even the first name? So we are submitting that it will be highly prejudicial and it will cause a miscarriage of justice if it could appear to the ninth accused that actually the state is focusing on him. Because you can see all those change of names is focused on one person. It's focused on the ninth accused. So what is this? That is the common denominator. That they don't want to take chances. Your Honor, the court should ask itself why the prosecution have not answered that question. We submit that allowing that application will be an abuse of the process of the court and it will cause substantial injustice to the ninth accused because it will appear as if there is something abnormal about it. We submit also, Your Honor, that it will appear discriminatory, which will violate Article 27, subsection 4, because it outlaws discrimination of any kind, either based on tribe, name, ethnic background, or any ground of discrimination. Your Honor, it will violate his fundamental rights and freedoms as protected under Article 50 clause 4 of the Constitution. It will also violate his rights under Article 50 clause 2K and J because it will inhibit his ability to interrogate and challenge the evidence that is intended to be brought against him. Your Honor, under Article 159, you have powers from the people of Kenya, sovereign powers, to administer justice to each and every person without regard to social status. Let the state tell us why they want to change Maina from number 9 to number 1. He was not even there during the search and the recovery. He was not in the premises. So we want to know why is this focus? That is an area of interest for us. Your Honor, we submit that doing that or allowing them to do that would be a miscarriage of justice, and that was never intended by the Constitution, which protects the right of everyone once the trial has commenced, if they did not have a case against the ninth accused person or the others. What was the hurry? They could have waited for 1 more week to do a better job. Who is this that was pressurizing them, Your Honor? We really want to know who was pushing this case. Who is the complainant in this case? Because this complainant looks like he's a very influential person, and he can even change names, he can change the numberings, he can change the priority, he can also decide to retain the vehicles. But thank God you have released the vehicles. So, Your Honor, we want the state to tell us what is in a number. Because they are changing Maina from number 9 to number 1 in all those counts. He has mentioned count 8, count 9, and count 10, and he has also talked of count 1. So we want to know what is in number. what is in numbers, what is in a name. Because it is nothing unless you work for a name to make it recognized. There's nothing. So we submit that it will be highly prejudicial to allow this application, and they will come up with an argument that it is their right to amend. Your Honor, we submit that Article 214 of the CPC belongs to the court. It does not belong to the prosecution. I have looked at Section 134 of the CPC. Your Honor, if they change those names as proposed in county 8, 9, and 10, it means the material particulars, the statement of the offense, and the material particulars as contemplated by Section 134 of the CPC, when you read it together with the Article 50, Clause 2A and B of the Constitution, which says the accused should be furnished with the proper particulars to be able to prepare and to appreciate what is against him, so that he is able to interrogate and challenge evidence. So, Your Honor, if that is allowed, it is like changing horses midstream. When we agreed on the competition and have selected horse A, and my brother selected horse B, then we are going to compete on equality of arms. But if my brother is allowed to change horses midstream, and he brings a horse that has taken some concoctions, then the competition will not be fair. So we submit that allowing them to change horses midstream when this case has taken off will be highly prejudicial to the defense case. And we urge you to reject the amendment. Let us take off with the charges that we read to the accused person. If it becomes necessary, Your Honor, you will give directions as and when we close that breach. I rest my case and allow my friends also to give their contribution, their understanding.
With your very kind permission,
This is Mr. Booth.
I will just, yes, that's Simon Goro, yes.
Simon.
I'll just highlight two issues. That is in respect to Section 214 of the CPC and the requirements thereof in terms of the application that has been done by the prosecution. This is in respect to whether the charges are defective, either in substance or in form. In the application that is before you, Your Honor, I humbly submit that the DPP has neither pointed this honorable court to the defect, either in the substance or in the form of the charges that were previously read to the accused persons. Bearing that in mind, Your Honor, I will humbly ask the court not to be swayed to exercise its discretion as granted under Section 214, noting the fact that the previous charge provides sufficient information to the accused persons of the specific
The
offenses.
previous charge
It provides sufficient information,
yes,
of the specific offenses that are faced to the accused persons, and that has not, and that that has not changed, or the prosecution has not shown that that information has been altered by the information that they seek to bring in now. Lastly, Your Honor, is reiterate the point that my senior has alluded to of a specific prosecutorial tendency that is geared towards one accused person, despite there being 12 other accused persons before you. what is the interest of the state in respect to this one accused person who now in the intended amendment will be accused number 1 and in the previous amendment was accused number 9. What is that interest? I rest my submissions. Thank you very much.
Your Honor, if I may give a quick response.
Yes, Mr. Omo.
Your Honor, it's right now that the prosecution can amend a judge at 10 time before close of the prosecution case. And that has to be done with the leave of the court. And that is why we have moved the court pursuant to section 214 of the CPC. Secondly, Your Honor, the defense has indicated that the accused persons will serve prejudice. I submit that no prejudice will be vested on the accused person, considering that the trial of this matter has not started. Today's mention was for the trial directions. Your Honor, I wish also to respond to the issue raised by my learned senior, the legal changing of horses. No horse has been changed, Your Honor. It's just giving the proper name to the proper horses and giving the proper dates when the offenses were committed. So no prejudice will be in this trial. Your Honor, the purpose of section 214 is to help cure substantive defects and the formal defects, Your Honor. As I indicated in my application, the name of the ninth accused person in the original charge was not indicated properly, and I want to use his proper name, Your Honor. I also made application grounded on the basis of dates. We submit that the dates indicated in the original chargeshit being 12 was not the date of the commission of the offense, and we wanted to be changed to 11, so that when the court is hearing the matter, it can hear it and the prosecution can present evidence supporting the offense which we are bringing before you. So, in view of the submissions which are made, I humbly urge this court to allow the application for amendment of statute and for the charges to be read with the accused persons. Thank you, Your Honor.